5 seconds to go. Start. The High Court in the judgment under appeal, however, primarily relied on the deeds executed on 14th July 1910 to sustain the claim of Chandu, since deceased, represented by his successors in interest. The High Court proceeded on the basis of three documents, being Exhibit B1 dated 7th May 1900 mortgage deed, Exhibit A20 dated 14 July 1910, which is the deed by which Chiruthi, Nangeli and Sanskaran, through Chiruthi, as he was minor at that point of time, created lease right in favor of Amma and her son Achuthan, and on the same date, Exhibit A1, a deed was also executed in favor of Chiruthi. Through the fourth deed, marked as Exhibit A2, Kutti Paravan surrendered his rights in the property to Chiruthi and Sanskaran. Questions were raised about admissibility of these documents before the High Court, but as marking of these documents were not objected before the trial court, the High Court held that at the stage of second appeal, such objections could not be raised. We accept the High Court's view on this point. The High Court also rejected the defendant's contention that both the deeds dated 14 July 1910 were strange transactions, as the aforesaid exhibits were not challenged by them at any point of time in the course of trial. We also do not find any flaw in the High Court's reasoning on this point also. Dealing with the appellant's case that Chiruthi was divested of any right to her late first husband's property by virtue of the 1856 Act, the High Court observed, learned counsel for the respondent submitted that on Madhavan's death, which was evidently before 1910, his rights devolved on Sanskaran. Chiruthi would not get any right on Madhavan's death as per the personal law applicable to the parties. The right of a widow to hold the property was recognized by the Hindu Women's Right to Property Act 1937. It is submitted that before 1937, Chiruthi had remarried Nilakandan, and therefore her right, if any, had lost by Section 2 of the Hindu Widows Remarriage Act 1856. I do not think that the contention put forward by the learned counsel for the respondents deserves acceptance. This is not a case where the rights of parties are to be ascertained, as if no document was executed and as if the property remained undivided. Exhibits A1 and A20 came into existence in 1910, by which the predecessor in interest of the defendants Sanskaran and his mother, who admittedly were having rights, lost possessory title. If Exhibit A20 is a valid and binding document, the question as to the rights of a widow and the extinguishment of the rights of the widow on remarriage do not arise for consideration. As stated earlier, the defendants are not entitled to challenge the validity of Exhibit A1 and A20 in defense to the suit for partition. The question whether the plaintiff has a right to get a share is to be determined with reference to the documents in existence, namely Exhibits A1, A2 and A20, and not with reference to what would have been the state of affairs had no document been executed. Stop.